Welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and click the notification bell so you can be updated every time we upload new content. It's our goal to upload new content every day at 8 a.m. Eastern Standard Time. Let's get started with question number 1. Martha's high school teacher told her that she was going to receive a failing grade in history, which would prevent her from graduating. Furious, she reported to the principal that the teacher had fondled her, and the teacher was fired. A year later, still unable to get work because of the scandal, the teacher committed suicide. Martha, remorseful, confessed that her accusation had been false. If Martha is charged with manslaughter, her best defense would be that she A. committed no act that proximately caused the teacher's death, B. did not intend to cause the teacher's death, C. did not act with malice, or D. acted under extreme emotional distress. Take 10 seconds and choose the best answer. Best answer would be A. A. She committed no act that proximately caused the teacher's death. The 4 elements of a crime consist of A. a guilty act, 2. B. a guilty mind, C. concurrence, and D. causation. Proximate causation is the natural and probable consequences of the defendant's act or a failure to act. Proximate cause is the philosophical connection which limits liability to consequences that bear some reasonable relationship to the actor's conduct so as to not offend notions of common sense, justice, and logic. In this case, the teacher committed suicide a year after Martha made the false accusation that the teacher fondled her. There is likely a question as to whether the teacher's suicide was a natural and probable consequence of Martha's act, because the teacher committed suicide a year after the false accusation. Had the suicide occurred soon after Martha's false accusation, then there would be more of a reasonable relationship between Martha's act and the teacher's suicide. As such, Martha's best defense would be that she committed no act that proximately caused the teacher's death. As to B, the intent question number 2, on April 1st, owner and buyer signed a writing in which owner, in consideration of $100 to be paid to owner by buyer, offered buyer the right to purchase Greenacre for $100,000 within 30 days. The writing further provided this offer will become effective as an option only if and when the $100 consideration is in fact paid. On April 20th, owner, having received no payment or other communication from buyer, sold and conveyed Greenacre to citizen for $120,000. On April 21st, owner received a letter from buyer enclosing a cashier's check for $100 payable to owner and stating, "I am hereby exercising my option to purchase Greenacre and am prepared to close whenever you're ready." For this question only, assume that, for whatever reason, buyer prevails in the suit against owner. Which of the following is buyer entitled to recover? A. Nominal damages only because the remedy of specific performance was not available to buyer. B. The fair market value, if any, of an assignable option to purchase Greenacre for $100,000. C. $20,000 plus the amount, if any, by which the fair market value of Greenacre on the date of owner's breach exceeded $120,000. Or D. The amount, if any, by which the fair market value of Greenacre on the date of the owner's breach exceeded $100,000. Take 10 seconds and choose the best answer. If you chose option D, you'd be correct. The amount, if any, by which the fair market value of Greenacre on the date of owner's breach exceeded $100,000. All the rules for monetary damages for breach of contract are premised on the protection of the plaintiff's expectation interest. Expectation damages are the damages sufficient to put the plaintiff in the position the plaintiff would have been had not the defendant in fact breached. Here, the amount buyer agreed to pay for Greenacre was $100,000. If the fair market value of Greenacre exceeded $100,000 on the owner's breach, then that difference is buyer's expectation damages. That difference would put buyer in the position buyer would have been if owner had not breached. Therefore, buyer would be entitled to recover the amount, if any, by which the fair market value of Greenacre on the date of owner's breach exceeded $100,000. While a portion of A is correct, that the remedy of specific performance is no longer available due to the sale, The issue of nominal damages and nominal damages only is in fact an improper statement of the rule. D is a significantly more correct statement where the plaintiff would be entitled to any overage or any profit during the time frame at the time of the breach. While B could arguably be very similar to D, the fair market value, if any, of an assignable option to purchase Greenacre for $100,000. You could theoretically argue that the fair market value of that option would be the overage, i.e. whatever profit one would be able to make on that purchase. However, D is a significantly more clear and appropriate statement of the rule. C, $20,000 plus the amount of any by which the fair market value of Greenacre on the date of owner's breach exceeded $120,000. Well, we're getting two numbers here that are being pulled out of nowhere, the $20,000 and the $120,000, given that the contract price was for $100,000. So the base number by which any damages would be calculated would be the amount in the agreement or the $100,000. So as a result, C doesn't touch upon any of the actual relevant facts, so D would be the correct answer. Question number 3. Phyllis suing Dennis for injuries suffered in an automobile collision. At trial, Phil's first witness, Wanda, testified that although she did not see the accident, she heard her friend Frank say, just before the crash, "Look at the crazy way old Dennis is driving." Dennis offers evidence to impeach Frank by asking Wanda, isn't it true that Frank beat up Dennis just the day before the collision? The question is, A, proper, because it tends to show the possible bias of Frank against Dennis. B, proper, because it tends to show Frank's character. C, improper, because Frank has no opportunity to explain or deny. Or D, improper, because impeachment cannot properly be by specific instances. Take 10 seconds and choose the best option now. This is one of the questions where logic simply prevails. A, proper, because it tends to show the possible bias of Frank against Dennis. Under the federal rules of evidence, the credibility of a witness may be attacked by any party, including the party calling him. Impeachment by evidence of bias, interest, or motive is allowed through cross-examination or extrinsic evidence. In this case, Dennis's impeachment of Frank on cross-examination of Wanda is through testimonial evidence of bias. If Frank beat up Dennis just the day before the collision, then Frank may have had reason to be biased against Dennis as opposed to accurately describing the way Dennis was driving. As such, the question is proper because it tends to show the possible bias of Frank against Dennis. Comparatively, B, with regards to Frank's character, generally character evidence is usually not permissible. So any answer that blanketly states character evidence is usually wrong. C is inaccurate. The opportunity for Frank to explain is quite irrelevant, and ultimately Frank is a party to the action in the sense that he is a witness, so there is cross-examination and direct examination. There's plenty of opportunity for Frank to explain. Finally, D, improper, because impeachment cannot be by specific instances. This is just an inaccurate statement of the law. There can be specific instances that are cited and specific evidence that is presented. That's usually the best form of evidence. Question number 4. Driver was driving his car near owner's house when owner's child darted into the street in front of driver's car. As driver swerved and braked his car to avoid hitting the child, the car skidded up into owner's driveway and stopped just short of owner, who was standing in the driveway and had witnessed the entire incident. Owner suffered serious emotional distress from witnessing the danger to his child and to himself. Neither owner nor his property was physically harmed. If owner asserts a claim for damages against driver, will owner prevail? A, yes, because driver's entry onto owner's land was unauthorized. B, yes, because owner suffered serious emotional distress by witnessing the danger to his child and to himself. C, no, unless driver was negligent. Or D, no, unless owner's child was exercising reasonable care. Take 10 seconds. Choose the best option now. If you chose option C, you'd be correct. No, unless driver was negligent. An intentional tort requires an intentional act by the defendant that causes the plaintiff's injury. A prima facie case of negligence requires a duty, a breach of that duty, causation, and actual damages. In this case, owner's potential claim for damages against driver rests on whether driver was acting intentionally or negligently. The facts presented make it clear driver did not intentionally cause owner to suffer emotional distress because driver avoided owner's child who darted into the street in front of driver's car. So owner cannot prevail under an intentional tort theory. However, if driver was acting negligently, then owner may recover under the theory of negligent infliction of emotional distress. Therefore, owner will not prevail unless driver was in fact negligent. If we look at the three other options, they generally don't make legal sense. Let's do some basic analysis. A, yes, because driver's entry onto owner's land was unauthorized. Just the mere fact that he was trespassing, or this is what an unauthorized entry into the land would be, a trespass. Just by mere fact of the trespass, that is not sufficient to give rise to liability. B, yes, because owner suffered serious emotional distress by witnessing the danger to his child and to himself. Ultimately, this is the argument, he's hurt because he's hurt. That's not much of a legal or logical argument. So generally, arguments which state A because A, you should generally stay away from. Option D, no, unless owner's child was exercising reasonable care. I'm not certain where this is coming from. Obviously, we're familiar with the reasonable care standard, or the reasonable person standard. However, the question of whether the child was behaving reasonably when they darted out into the street is almost oxymoronic. Let's move on to question number 5. On May 1st, 1987, a car driven by Deborah struck Peggy, a pedestrian. On July 1st, 1987, with regards to this incident, Deborah pleaded guilty to reckless driving, which is a misdemeanor, and was sentenced to 30 days in jail and a fine of $1,000. She served the sentence and paid the fine. On April 1st, 1988, Peggy died as a result of the injuries she suffered in the accident. On March 1st, 1991, a grand jury indicted Deborah on a charge of manslaughter of Peggy. On May 15th, 1991, trial had not begun, and Deborah filed a motion to dismiss the indictment on the ground of double jeopardy, and that her conviction of reckless driving arose out of the same incident, and on the ground that the 3-year statute of limitation for manslaughter had run. Deborah's motion should be A, granted only on double jeopardy grounds, B, granted only on statute of limitations grounds, C, granted on either double jeopardy grounds or statute of limitation grounds, or D, denied on both grounds. Take 10 seconds and choose the best answer now. Best answer would be D, denied on both grounds. Under the Fifth Amendment, there's a right to be free of double jeopardy for the same offense. Two crimes do not constitute the same offense if each crime requires an element that the other does not. A crime must have at least one different element from the other crime to be considered different crimes for the purpose of double jeopardy. The attachment of jeopardy for the greater offense bars the retrial of a defendant for a lesser included offense. The attachment of jeopardy for a lesser offense bars the retrial of a defendant for greater included offenses, except in the case of battery, where the victim subsequently dies, in which case the defendant may be retried for murder, or where the unlawful conduct for the greater included offense had not yet occurred or was not yet discovered despite due diligence. The statute of limitations for starting a criminal proceeding generally begins to run on the date the crime was committed. Here, Deborah had pleaded guilty to reckless driving. The attachment of jeopardy for a lesser offense bars the retrial of Deborah for a greater included offense, i.e. the manslaughter. However, there is an exception to the lesser offense bar if the unlawful conduct for the greater included offense had not yet occurred. Peggy died after Deborah had pleaded guilty to reckless driving, so no death had yet occurred for manslaughter. A proper manslaughter charge could only be filed after Peggy died. The statute of limitations for starting the manslaughter proceeding began to run on April 1st, 1988, because that is when Peggy died. The grand jury indicted Deborah on March 1st, 1991, which was 1 month less than the 3-year statute of limitations for manslaughter. Therefore, Deborah's motion should be denied on both grounds. Now on to question number 6. 2 police officers in uniform were on foot patrol in a neighborhood frequented by drug sellers. They saw Sandra, who when she saw them, turned around and started to walk away quickly. The police ran after her and shouted, "Stop and don't take another step, lady." Sandra turned, looked at the police, and stopped. She put her arms up in the air. As the police approached, she threw a small object into nearby bushes. The police retrieved the object, which turned out to be a small bag of cocaine, and then arrested Sandra. Sandra is charged with possession of that cocaine. She moves pre-trial to suppress its use as evidence on the ground that it was obtained as a result of an illegal search and seizure. Her motion should be A, granted because the police did not know the item was cocaine until after they had seized it. B, granted because the police acquired the cocaine as a result of an unlawful seizure. C, denied because the police had probable cause to seize the bag. Or D, denied because Sandra's voluntarily discardment of the contraband. Take 10 seconds and choose the best option. The correct answer would be B, granted because the police acquired the cocaine as the result of an unlawful seizure. The rule is that an officer who has an articulable and reasonable suspicion to believe that a person was, is, or will be engaged in criminal activity may stop the subject and conduct a warrantless frisk for weapons. This is called a Terry stop. For example, police may have reasonable suspicion to detain someone who fits a description of a criminal suspect, a suspect who drops a suspicious object after seeing police, or a suspect in a high crime area who runs after seeing the police. In this case, the two officers saw Sandra walking in a neighborhood frequented by drug dealers, and when she saw the officers, she turned around and started to walk away quickly. The issue in this question is whether Sandra walking away quickly after seeing the police is sufficient to give the officers reasonable suspicion to stop her. The problem here is that Sandra did not run from the police. She just walked away quickly, so this is unlikely to be sufficient to create reasonable suspicion without more. As such, Sandra's motion should be granted because the police acquired the cocaine as a result of an unlawful seizure. It is important to keep in mind that this question is a very close call because if Sandra turned and ran from the police in a neighborhood frequented by drug dealers, it would likely be sufficient cause to find reasonable suspicion. Let's look at the other choices. A, granted because the police did not know the item was cocaine until after they had seized it. Now, in fact, while this is probably very true, it's also irrelevant because ultimately the police are not charged with knowing what an item is that's discarded prior to it being discarded. They cannot be charged with the same foresight of Nostradamus. Option C, denied because the police had probable cause to seize the package. In essence, that is your judgment call. Did they or did they not have sufficient cause? Here, the argument is, given the fact that the person did not flee by running, that in fact that did not give sufficient cause for the officers to have probable cause in order to search, and as a result, in order to seize the package. Finally, D, denied because Sandra voluntarily discarded the contraband. This ignores the fact that the discardment is really not the question, more so the approach. Remember that a stop is taken holistically. If the stop is deemed inappropriate from the onset or illegal from the onset, then everything that results as a result of that search is deemed inadmissible. Question number 7. On June 1st, seller and buyer contracted in writing for the sale and purchase of seller's cattle ranch, a large single tract, and to close the transaction on December 1st. For this question only, assume the following facts. On October 1st, buyer told seller, "I'm increasingly unhappy about our June 1st contract because of the current cattle market and do not intend to buy your ranch unless I'm legally obligated to do so." If seller sues buyer on October 15th for breach of contract, seller will probably A, win because buyer committed a total breach by anticipatory repudiation on October 1st. B, win because buyer's October 1st statement created reasonable grounds for seller's insecurity with respect to buyer's performance. C, lose because the parties contracted for the sale and conveyance of a single tract and seller cannot bring suit for breach of such a contract prior to the agreed closing date. Or D, lose because buyer's October 1st statement to seller was neither a repudiation nor a present breach of the June 1st contract. Take 10 seconds. If If you chose option D, you'd be correct, lose, because buyer's October 1st statement to seller was neither a repudiation nor a present breach of the June 1st contract. The rule is that where a party unambiguously states by words or conduct to the other party before the time for performance has arisen that she will not perform, that she is unable to perform, the other party is entitled to treat that as an anticipatory repudiation. That generally excuses performance by the non-repudiating party. A breach of contract occurs when a party to the contract does not perform after performance comes due. In this case, buyer told seller on October 1st, "I'm increasingly unhappy about our June 1st contract because of the current cattle market and do not intend to buy your ranch unless I'm legally obligated to do so." Since this language is not unambiguous, it is not sufficient to find an anticipatory repudiation, and therefore seller will probably lose since buyer's performance is due on December 1st and has not occurred yet. Let's look at the other options. A, win because there's been a full anticipatory repudiation on October 1st. That is the key question here. Is that statement repudiation or not? Generally, again, it has to be unequivocal. Think back to criminal law classes where the question of an assault generally comes to mind, and that being contingent upon some other factors, such as, I would hit you if. Generally, that's not deemed sufficient because there is a contingency in place. B, win because buyer's October 1st statement created reasonable grounds for seller's insecurity with respect to buyer's performance. Now, that is not a legal standard. There is no lawsuit for insecurity with respect to buyer's performance. Either there is or there isn't, or there will be or there won't. You cannot file suit because you feel that the other party may not perform. That is in essence what B is saying. And finally, C, lose because the parties contracted for the sale and conveyance of a single tract and the seller cannot bring suit for breach of such a contract prior to the agreed closing date. While this is generally true, however, if there is in fact a repudiation, then ultimately suit can be brought at the time of that repudiation. You would not have to wait for the date of specific performance. So as a result, C would be an inaccurate statement of the law, and D would be the most correct statement and the best answer. Question number 8. The governor of the state of Green proposes to place a Christmas nativity scene, the components of which would be permanently donated to the state by private citizens. In the Green Capitol Building Rotunda, where the Green legislature meets annually, the governor further proposed to display the state-owned nativity scene annually from December 1st to December 31st, next to permanent displays that depict the various products manufactured in Green. The governor's proposal is supported by all members of both houses of the legislature. If challenged in a lawsuit on Establishment Clause grounds, the proposed nativity scene would be held A, unconstitutional because the components of the nativity scene would be owned by the state rather than by a private person. B, unconstitutional because the nativity scene would not be displayed in a context that appeared to depict and commemorate the Christmas season as a primarily secular holiday. C, constitutional because the components of the nativity scene would be donated to the state by private citizens rather than purchased with state funds. Or D, constitutional because the nativity scene would be displayed alongside an exhibit of various products manufactured in Green. Take 10 seconds and choose the best option. If you chose option B, unconstitutional because the nativity scene would not be displayed in a context that appeared to depict and commemorate the Christmas season as a primarily secular holiday, you'd be correct. The rule is that displays of religious themes are permissible so long as the religious symbols are surrounded by primarily secular symbols. In this case, the governor of the state of Green has proposed to place a Christmas nativity scene in the Green Capitol Building Rotunda next to permanent displays that depict various products manufactured in Green. Unfortunately, however, displaying this nativity scene next to displays that depict the various products manufactured in Green does not satisfy the requirement that displays of religious themes be surrounded by primarily secular items. As such, the proposed nativity scene display would be held unconstitutional. Question number 9. Defendant was charged with attempted murder of Victor in a sniping incident in which defendant allegedly shot at Victor from ambush as Victor drove his car along an expressway. The prosecutor offers evidence that 7 years earlier, defendant had fired a shotgun into a woman's home and that defendant had once pointed a handgun at another driver while driving on the street. This evidence should be A. Excluded because such evidence can be elicited only during cross-examination. B. Excluded because it is improper character evidence. C. Admitted as evidence of defendant's propensity towards violence. Or D. Admitted as relevant evidence of defendant's identity, plan, or motive. Take 10 seconds. Correct answer is B. Excluded because it is improper character evidence. Evidence of a person's character or trait of character is not admissible for the purpose of proving action in conformity therewith on a particular occasion, except as otherwise provided in the law. In a criminal case, no character evidence is admissible during the prosecution's case in chief unless it is a sexual assault or child molestation or the court has admitted evidence of the victim's character. The prosecution can only rebut character evidence introduced by the defendant first. Here, the prosecutors offered evidence paints the defendant's character as a person who shoots other people for the actual purpose of proving the defendant shot Victor. However, since this is not a sexual assault or child molestation case, and the court has no admitted evidence of the victim's character, the prosecution cannot be first to introduce this evidence. As such, it is an improper use of the character evidence in this criminal trial, and the evidence should properly be excluded. A is inaccurate because it states that the testimony can only be elicited during cross-examination, but it doesn't specify cross-examination of who. C is without question not permissible. It states that it's admitted as evidence of defendant's propensity towards violence. You cannot submit evidence or permit evidence to be submitted with regards to a propensity towards a crime if you are then attempting to prove that the defendant in fact committed this type of crime because he has a propensity for committing these types of crime. That would be the epitome of prejudicial. And finally, D, admitted as relevant evidence of defendant's identity, plan, and motive, makes 0 sense. So that is the one option which you can discard immediately on a question like this. For the most part, when you're looking at questions like this, you will have one question, one answer, I should say, that you can discard immediately. Here, D would be the one that you should discard immediately. You're left then at that point with a few other options. If you look at C, think of yourself as rewording some of these answers. For example, admitted as evidence of defendant's propensity towards violence. If you reword that answer, in essence, what they're saying is the defendant is guilty because he's a bad guy and he's done this before. Ultimately, that is not a sufficient cause, or that should not be admitted as evidence. Now let's look at our final question in this grouping, question number 10. Traveler was a passenger on a commercial aircraft owned and operated by airline. The aircraft crashed into a mountain, killing everyone on board. The flying weather was good. Traveler's legal representative brought a wrongful death action against the airline. At trial, the legal representative offered no expert or other testimony as to the cause of the crash. On airline's motion to dismiss, at the conclusion of the legal representative's case, the court should A. Grant the motion because the legal representative has offered no evidence as to the cause of the crash. B. Grant the motion because the legal representative has failed to offer evidence negating the possibility that the crash may have been caused by mechanical failure that airline could not have prevented. C. Deny the motion because the jury may infer that the aircraft crashed due to airline's negligence. Or D. Deny the motion because in the circumstances, common carriers are strictly liable. Take 10 seconds and choose the best option. If you chose option C, you'd be correct. Deny the motion because the jury may infer that the aircraft crashed due to airline's negligence. To establish a prima facie case of negligence, the plaintiff must prove a duty, a breach of that duty, causation, and damages. The doctrine of res ipsa loquitur applies when the plaintiff does not have direct evidence of the defendant's negligence conduct. In order for res ipsa loquitur to apply, there must be no direct evidence as to the defendant's precise conduct. The accident must not normally occur without negligence by someone, and the defendant must be the most likely person whose negligence would have caused the accident. With res ipsa loquitur, the plaintiff is treated as having produced enough evidence of the defendant's negligence. However, the defendant may rebut this evidence, and the jury is also free to reject the res ipsa loquitur inference. In this case, Traveler's legal representative did not offer expert or other testimony as to airline's negligence in causing the crash. Res ipsa loquitur likely applies because while there is no direct evidence as to airline's precise conduct, an aircraft crashing into a mountain during good weather conditions does not normally occur without negligence by someone, and this aircraft was an airline's exclusive control. Traveler will be treated as having produced enough evidence of airline's negligence for the case to go to the jury. Therefore, the court should deny the motion to dismiss because the jury may infer that the aircraft crashed due to airline's negligence. If we look at the other options, A, grant the motion because the legal representative has presented no evidence. That is directly in contradiction to C, which is the res ipsa loquitur rule. And ultimately, if we return back to our thoughts of liability and we think of the piano falling from the hotel room case, without question, there can be liability without the ability to prove or present evidence that the defendant in fact directly caused the harm. B is equally and in the same way incorrect. Grant the motion because the legal representative has failed to offer evidence negating the possibility that the crash may have been caused by mechanical failure that airline could not have prevented. Although it's worded a bit odd and it seems like proving a negative, so we can erase or remove B as a possible option right off the bat. Finally, option D, deny the motion because the circumstances common carriers are strictly liable. That is in fact not accurate, and ultimately there would have to be some sort of causation and some sort of breach. As a result, there would not be strict liability under these circumstances. So the only correct option would be C. Thank you again for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam, 10 questions at a time. Don't forget to like, subscribe, and ring the notification bell so you can be updated every time we upload new content. And it's our goal to upload new content at least every day at 8 a.m.